Hello everyone, this is Tom Fox, and I would like to welcome you to episode 118 of the FCPA Compliance and Ethics Report. In this episode, I take a deep dive into the Alstom enforcement action. I take a look at the best practices compliance program in some detail for the compliance practitioner so that you can benchmark where you are against the DOJ's current thinking. I take a look at some of the larger issues raised by the FCPA enforcement action. I review some of the comments by the FCPA professor and Dick Casson and the FCPA blog on his thoughts as well. The episode comes in at just over 23 minutes, and I hope you enjoy it. Thank you. Hello everyone, this is Tom Fox, and I would like to welcome you to this episode of the FCPA Compliance and Ethics Report. This is my second podcast of 2015, and I wanted to take a look at the Alstom FCPA enforcement action, which was announced in December of 2014. This followed directly on the heels of Avon, and it was almost as stunning as the Avon enforcement action. So I thought it would be appropriate to take a little bit of a deep dive into the Alstom enforcement action. First and foremost about this case is that it comes in at number 2 on the all-time list of FCPA enforcement fines and penalties of all time ever. As everyone's pretty well aware, Siemens is number 1 at $800 million, but that $800 million consists of both a criminal fine of $450 million and a civil fine of $350 million. Alstom did not pay a civil fine. It is not currently an issuer under the definition under the FCPA, not subject to SEC jurisdiction. And so a $772 million fine was paid, all on the criminal side. So it comes in as number 1 as the all-time criminal fine. And that speaks directly to several key components of the Alstom FCPA resolution. And the DOJ is clearly communicating that with this fine, some of the things that it wants to see going forward. Since the fine comes in at number 2, of course, it's a good opportunity to review and consider the top 10 fines of all time. And what we now see is that only 2 U.S. companies, Halliburton at number 2 and Alcoa at, I believe, number 5 now on the top 10. The rest are foreign companies. We're going to talk about that in a little bit. The amount of the fines paid was significantly higher than those paid by Avon. And if you recall, Avon paid bribes paid by Avon. Avon paid bribes of a little over $8 million at a total fine of $135 million. However, Alstom had a fines paid of at least $75 million. When with this, they got reported over $4 billion in contracts and $296 million in profits. What we do not have, information-wise, that we had in the Avon case is the cost of the investigation. Nevertheless, the investigations and enforcement actions span several different companies and continents. Alstom clearly had a worldwide bribery scheme in place and a culture that, while it may not have been corrupt, it certainly wasn't against paying a good bribe to get some business. The enforcement action involved matters in Indonesia, Egypt, Saudi Arabia, the Bahamas, Taiwan, and I think there may have been, I think that was it. And there were numerous enforcement agencies from foreign countries involved, including the Attorney General in Switzerland, the Serious Fraud Office in the United Kingdom, authorities in Germany, Italy, Singapore, Saudi Arabia, Cyprus, and Taiwan. It truly was worldwide in scope. So there were 4 resolutions in the Alstom matter. There was the resolution of the parent company in France, Alstom SA, and there were 4 subsidiaries involved. And the parent received a deferred prosecution agreement. And then there were, 3 subsidiaries. One which I'm going to call Alstom Prom, or it was rather Alstom Network Schweiz AG, as Alstom Power Inc. and Alstom Grid Inc. There were criminal informations filed against each of those entities, and they listed out various components of the bribery scheme. Alstom Network Schweiz pled guilty to conspiracy to violate the FCPA anti-bribery provisions based upon conduct in Indonesia, Saudi Arabia, Egypt, and Bahamas. Alstom Power pled guilty to conspiracy to violate the FCPA's anti-bribery provisions based on conduct in Indonesia, Saudi Arabia, and Egypt. And Alstom Grid Inc. Pled guilty to conspiracy to violate the FCPA based on its conduct in Egypt. One of the more interesting things was Alstom SA, the French parent company, pled guilty to a number of books and records or accounting provision violation, books and records and internal controls. And the thing that makes this a little bit interesting was that Alstom SA was an issuer because it issued stock in the United States up until 2004, but thereafter was not. So we're going to explore that in some detail later because the FCPA professor has raised a very interesting question, which he entitled a real head scratcher as to why Alstom pleaded guilty to substantive violations of legal provisions of the FCPA in 2014 that last applied to the company in 2004. So we're going to see if we can take a look at this. Each of the resolutions had a deferred prosecution agreement with a similar attachment C, minimum best practices in place, and I think that's going to be pretty significant for the compliance practitioner going forward. So I'd like to go into that in a little bit of detail. There were 10 points that were put into the best practices. It's a little bit different formulation than the 10 hallmarks of an effective compliance program that we saw in the FCPA guidance. Nevertheless, most of the concepts are similar. So let me just go through these because I think it's important for the compliance practitioner. Number one, a high-level commitment. A company must ensure that its directors and senior management provide strong, explicit, and visible commitment to a corporate compliance policy, clearly the tone at the top. Number two, code of conduct, policies and procedures, and internal controls. A company should have a clearly articulated and visible corporate compliance policy memorialized in a corporate compliance code of conduct. The policies and procedures should address the following areas: gifts, hospitality, entertainment, customer travel, political contributions, charitable donation and sponsorships, that's new, facilitation payments, and solicitation and extortion payments. There should be a system of financial and accounting procedures, i.e. internal controls, designed to provide reasonable assurance of the four following components: that transactions are executed with management's general or specific authorization, transactions are recorded as necessary to permit preparation of financial statements in conformity with generally accepted accounting principles and to maintain accountability for assets. Access to company assets are only permitted with management general or specific authorization, and there is a testing of assets at regular intervals. Number three, risk-based review. A company should periodically review and evaluate, really no less than annually, the compliance codes on the basis of a risk assessment addressing the individual circumstances of the company, including the following different components: geographic organizations, interactions with various types of government officials, industrial sectors of operation, involvement in joint venture arrangements, importance of licenses and permits in the company's operations, degree of government oversight and inspection, and the volume and importance of goods and personnel clearing through customs and immigration. A company should also update its compliance program, taking into account, quote, relevant developments in the field and involving international and industry standards. Number four, proper oversight and independence. A company should assign responsibility to the senior executives for the implementation and oversight of the compliance program. Those executives must have the authority to report directly to independent monitoring bodies, including the internal audit and function and the board of directors, and should have autonomy from management. Compliance programs need to be funded and they need to have an appropriate level of resources. Number five, training and guidance. A company should implement mechanisms to ensure that its compliance code of conduct is effectively communicated to all directors, officers, employees. This means repeated communication, frequent and effective training, and the ability to provide day-to-day guidance when the issues arise. Number 6, internal reporting and investigation. Alstom should have an effective, or a company rather, should have an effective system for confidential internal reporting of compliance violations. It must establish effective procedures with sufficient resources for responding to, investigating, and documenting the allegations of violations. Number 7, enforcement and discipline. The company should implement mechanisms designed to enforce its compliance code, including the appropriately incentivizing compliance and disciplining violations. This requires also that misconduct be remedies and steps taken to ensure no recidivism. Third-party relationships. I've spoken about this at length, and it's clearly still one of the big bugaboos of compliance, anti-corruption compliance, and you need to have an effective third-party management program in place. This includes the full 5 steps in the life cycle of third-party management. Number 9, mergers and acquisition. A company must perform pre-acquisition due diligence on any target companies it's looking at and engage in appropriate risk assessment and due diligence of its legal compliance accounting functions. If an acquisition is made, a company must integrate its compliance program into the newly acquired entity as soon as is practicable and put on an appropriate level of training, and when warranted, conduct an FCPA-specific audit of the newly acquired or merged businesses and report the results to the Department of Justice. And finally, monitoring and testing. A company should conduct periodic reviews of its testing of its compliance code to improve its effectiveness and to prevent and detect violations. In other words, you've got to kick the tire regularly. Excuse me. A compliance program must evolve with changes in the law and practices in technology and culture. So this is the steps of an effective compliance program. This is something that a compliance practitioner needs to take a look at. You can benchmark where you are, where your program is against this. It's significant information because it's important to understand the department's most current thinking. Clearly, its thinking is evolving, and your program needs to evolve. This includes technological solutions. This includes industry standards. It's something that your program simply cannot be static. It has to be dynamic. One of the interesting questions, or issues rather, that I would say is posed by the FCPA professor in his blog post entitled, appropriately, Issues to Consider from the Alstom Action, is this issue of the books and records or the accounting provision violations that Alstom agreed to, and why did a company agree to this who hasn't been an issuer in 10 years. So the parent Alstom agreed to violations of the books and records, the accounting provisions, both books and records and internal controls, which typically only refer to the to issuers. And the question is, why would they have done so? The accounting provisions of the FCPA require that every issuer of securities must make and keep books and records and accounts in reasonable detail, which accurately and fairly reflect the transactions and dispositions of assets of the issuers. It must devise and maintain a system of internal accounting controls sufficient to provide reasonable assurances that no person knowingly can circumvent or knowingly fail to do so or falsify books and records. So here I have to go into a little bit of speculation because it's not clear precisely why Alstom SA, the French parent, would do so. But there are a couple of reasons that come to mind. The first one is that by agreeing to the books and records violation, it may keep Alstom from being debarred for certain government work. If they had agreed to substantive FCPA bribery violations, perhaps that may have meant something down the line. It may have been that they did not want to do so for fear of making certain corporate officers more liable. It may have been that under French law, they could agree to, or rather, they could agree to this violation of American law, and it wouldn't negatively affect them under French law. It may also be that GE did not want the parent company to admit to substantive FCPA violations. But to me, it really doesn't matter. Alstom's conduct was clearly violative of the FCPA, and I don't think that it hurt Alstom to make this admission. This was a negotiated settlement. It wasn't a diktat by the Department of Justice, although they certainly, I'm sure, negotiated very hard because they had substantive facts on their side. So I'm not too concerned that this is going to set a negative precedent or some other type of precedent that's outside the law of the FCPA, because clearly for the time period in question, Alstom was an issue, that being 1999 to 2004, and Alstom did not, or did really rather engage in these violations. Some other questions I thought were very interesting that were posed by the FCPA professor included the following. What were the enforcement actions or origins? In other words, how did this enforcement action start? He believed that it appeared to be a 2011 Swiss enforcement action, or in Switzerland, which actually began in 2007. So 4-year resolution. It's not really clear if that's the case. Nevertheless, it's certainly one possibility. A second and extremely interesting point that the professor raised is there's no monitor involved. And the question is, if the conduct was this bad, why was there no monitor? Well, part of it's answered by the settlement documents themselves, which require that Alstom comply with a previously agreed upon settlement with the World Bank, where the World Bank would monitor Alstom. And as long as the World Bank was satisfied, that Alstom did not have to bring a monitor in. It may also be with the upcoming merger or acquisition by General Electric, the government had confidence that the GE program would be enough to bring Alstom into line, at least under the FCPA. But nevertheless, a very interesting point raised by the professor. The professor also raised an issue about the more information needed as to the lack of cooperation. The settlement documents were replete with references to Alstom not cooperating, obstructing justice, failing to provide documents, limiting cooperation. The fine amount reflected that. Alstom received a clear penalty. They did not receive any discount. Indeed, the fine range was directly the fine was directly in the middle of the fine range. So there was clear lack of cooperation, but the professor thought it would be, and here I would agree with him, that more useful to have the failure to cooperate specified in some of the settlement documents, although I recognize Alstom in a negotiated settlement agreement may not be is so inclined to air that dirty linen in public. The couple of other points the professor raised is the foreign government official definition a stretch because of some of the conduct that Alstom engaged in. Specifically, he talked about joint venture partners and some other business entities that he raised questions about whether or not a U.S. employee assigned to such a joint venture or other entity would be a foreign official for the purposes of the Department of Justice. He raised the issue of how should you count an FCPA enforcement action. As if you've read the professor or heard him speak, you know he talks about his core approach. And here I have to agree with him that really this is just seemed to me to be one FCPA enforcement action, no matter how many entities or settlement documents were involved. So very interesting issues raised by the professor. Certainly bear more discussion. I've contemporaneously with the posting of this podcast have posted a couple of posts on Alstom, and I'll be posting one on the accounting provision violation and giving some of my thoughts on that. So I hope the debate will continue on that point. There's one point or one some thoughts I'd like to conclude with, and these come from Dick Casson. Dick's the editor of the FCPA blog, and he has a post entitled "From Alstom: 6 Reasons Why U.S. Companies Dominate the Top 10 List." I indicated that Alstom, with Alstom coming in, we now have 2 U.S. companies in the top 10 FCPA enforcement actions of all time. And so the question becomes, why is this so? And he had a very interesting post today that I thought merited further discussion. So let me just go through Dick's list here. And he's got, like I said, as his title indicates, 6 reasons. So let's just visit these. First, Alstom didn't have an effective compliance program. And he thinks that that's clearly true of all of the companies that were in the top 10. But non-U.S. companies are more likely to be FCPA compliance laggards. They don't seem to understand that the FCPA applies to them and don't recognize the risks of FCPA offenses in enforcement. Or maybe they're just U.S. phobic and they don't think U.S. law applies to them. Well, wake up and smell the roses, buckaroos. Second, bribery was Alstom's way of doing business. I think that's true, and as we now know about other French companies, that's true, and perhaps big showy bribery are more associated now with non-U.S. companies. 3, Alstom and other non-U.S. companies aren't really hard to catch. This is not a reference to NSA spying to detect FCPA compliance or FCPA violations, but explicit emails, phony consulting agreements, doctored invoices, trails of money transfer, travel records are something that probably companies outside the U.S. expose themselves to a little bit more than U.S. companies who've gone through litigation and have in-house counsel screaming, don't put stupid stuff in emails. 4, Alstom stonewalled the feds, and Dick's right up front says this is a very bad idea. U.S. companies tend to self-report and cooperate because they want those credits. Non-U.S. executives don't seem to understand that they need to do this too. They think that a bloody battle over a case will create leverage for a favorable settlement later. This bucker mentality, however, does not work with the DOJ. 5th, Alstom is from France, a country with a weak enforcement record. Clearly, if we look at the Total case, where Total pled guilty, yet the executives involved could not be convicted under French law, there's a wide variance in legal jurisprudence over what constitutes bribery and corruption, and in France, they seem to have a bit of a different standard. 6, a company is more likely to land on the top 10 list when senior executives are culpable. This is certainly true throughout the top 10 lists, but overseas, I think we find that this is a little more likely, as senior executives, once again, don't seem to think the FCPA applies to them. But it does. So lots of takeaways here, lots of interesting points raised by some of the commentators. I hope that you will join in on this debate if you have some issues that you think should be raised or want to comment on. You can contact me at tfox@tfoxlaw.com. You can leave a comment on my blog post, the FCPA Compliance and Ethics blog, or a comment to this podcast at the FCPA Compliance and Ethics Report. This is Tom Fox, and I hope you have enjoyed this episode. Thank you very much.